Welcome to this MedicoLegal Dilemmas, Myths and Facts Explained for the Practicing Ophthalmologist. I am thankful to the Scientific Committee, AIOS, for allowing us to present this course. Dear friends, as we all know, these are very turbulent times for our ophthalmic practice. Basically, any medical practice is going through these turbulent times. So, eye care centers told to pay so and so amount for patient vision loss and doctors getting sued. These are all common headlines that we see nowadays. And as a doctor, claiming ignorance of law is no excuse for us. Ignorance regarding one's legal liabilities and legal duties by an ophthalmologist often lands the ophthalmologist as a defendant in front of court of law. And we are made to face the ignominy of trial either in the consumer or criminal court, or many a times in both the courts simultaneously. The current climate in our country is such that increasing number of court cases are being filed up against ophthalmologists due to degrading patient-doctor relation and erosion of mutual trust. Media also plays a big hand in this. Even government and administration setups, agencies are increasingly targeting ophthalmologists for alleged or pursued malpractices. So in such scenarios, we must have a basic outline of what is expected us from medical legal viewpoint, and keeping that in mind, we have designed this instruction course with myself, Dr. Viral Shah from Nagpur. We will be having with us Dr. Prakash Marate sir from Pune. We will be speaking on CPA, Consumer Protection Act of 2019. Consents in ophthalmology will be covered by myself. Medical record keeping will be covered by Dr. Rajesh Joshi from Nagpur. And how to tackle a legal notice received. Dr. Anand Deshpande sir is with us from Aurangabad. He will be covering this important aspect. Landmark court judgments in ophthalmology will be covered by Dr. Srinivas Joshi from Hubli, and a word about professional indemnity insurance will be dealt by Dr. Parikshit Gokte. And after that, we will be having some panel discussion. So this is our IC, and now I request Dr. Prakash Marate sir to please brief us about the changes in CPA 2019.
Hello, good evening everyone. Thank you Dr. Viral Shah for accommodating me in your instruction course of medical legal aspects. The topic allotted to me is Consumer Protection Act 2019. Myths and facts explained for the ophthalmologist. Basically, Consumer Protection Act was there since 1986. But then new provisions were added around 2020. But the name of the act is 2019. And it is quite problematic act, and those revisions which government tried to make were troublesome for medical profession. What new things were added in this particular act apart from previous act? So this particular slide explains what were the additions and what were the changes. First thing is, there was a rumor that this particular CPA 2019 is not applicable to medical profession. And so there was confusion amongst the minds of people of medical profession whether it is applicable to them or not. So they were very happy. So there were messages moving everywhere that it is not applicable. But unless and until medical profession is excluded from the list of the government, that it is not applicable for that particular profession, it is applicable to all other professions. So it is applicable to medical profession also. So just take it from me. Another thing is compensation amount was increased, and that was the worst thing. From lakhs of rupees it went to crores of rupees. But only thing is, there is one provision in that act, that is that particular compensation amount is linked with in some way that what are the bills produced. Then one important thing is that in the past that particular CPA complaint was lodged in the area where the doctor was practicing, because that was the jurisdiction. And now according to this one, the jurisdiction can be anywhere in India. Suppose the doctor is in Kochi and patient is from Chandigarh, he can lodge the complaint in Chandigarh also. And that is quite troublesome for that medical practitioner. And then one important addition is that provision of consumer mediation cells. So this is that way good or good and bad. Good in the sense that the case can be settled, but there are certain agencies, they are taking advantage of this and they are trying to become mediators and they are trying to take out the money from the medical professionals just for settlement purpose. So this Consumer Protection Act basically is related to doctor-patient relationship. In the past, doctor-patient relationship was very good, not that hampered. And according to this particular law, doctor was the profession, but now they are treating it as business. Doctor is a seller. And the same way patient was client in the past, but now he is a buyer, he is the consumer. So this way the definition has been changed. So they are linking it is pro-patient. What government thought that it will be beneficial for the patient. But then in the end, it is becoming anti-doctor. But patients are also receiving bad taste of it. Like defensive practice, so many investigations are needed just to safeguard the medical profession. For medical legal protection, what has been done for that? Few of the investigations are needed. CT, MRI, CAT scan is also advised. And patients and relatives, they may feel that it is not that important why it is done. But then to protect doctor himself, he tells that some diagnosis should not be missed. And most of the times even second opinion is asked for. So defensive practice is the trend. There is faith. There was faith. Still there is faith. But then element of suspicion has been increasing in the patients and relatives' minds. So that is the worst part of it. And that way, society, doctors, patients, everyone is getting affected. So both are affected. So the goal which was set in front of the government is not achieved. So doctor is answerable surely to medical council, civil courts, criminal courts, consumer redressal, Janta Darbar, all simultaneously or sequentially. So this is the worst part. Then CPI is a special law of civil nature with the aim of a social welfare to protect consumers with following features. No court fee. Now it is up to 5,000. Again, this is a very small amount. Simple procedure of filing, hearing and deciding, etc. Summary trial is also there and speedy redressal, that is the aim, which is still not achieved. So non-judicial members of forum, on forum, one has to be female. So that's what their description is. Not a court, but has a full force of it, that is quasi-judicial. Majority opinion is the order of the forum. Act is compensatory and not preventive or punitive. That is very important. Applies to all paid goods and services, but only free services covered are medical. That is quite unfortunate. So jurisdiction, district forum, it was less than 20 lakhs in the past. They have proposed up to rupees 1 crore. State commission in the past, it was 20 to 100 lakhs. That was up to 1 crore. Now it has been raised to 10 crores. So appeals plus administrative powers. In national, it was more than 100 lakhs. That was up to 1 crore. Now it has increased to more than 10 crores. So revision appeals, administrative, and no power of reviewing own orders. So these are the worst things. The amount has gone in crores and crores of rupees. So period of limitation, 2 years. For appeals, 30 days. So condonation possible. So what is the procedure? Summary procedure, complaint in 4 or 6 copies with affidavit, referred to opposite parties, reply in 30 days, can be extended more 15 days. Then hearing by president, one president, at least one member. Lawyer is not mandatory, so anybody can go there. Evidence of affidavit, expert, book references, if elaborate, may be asked to go to civil court. Order to be signed by president and only minimum one member. So ex parte decision is possible. Suppose the complaint is against the medical professional and he is not going there, the ex parte decision also can be taken. Then appeal system. So district forum, if not resolved, state commission, if not resolved, it goes to national commission, and at the end, Supreme Court can be attended. So proposed changes, power of interim orders, power of injunctions, increasing pecuniary jurisdictions, national commission, only appellate jurisdiction, and more benches of state and national commissions. So I am thankful for giving me the opportunity, and I pray Almighty, all of you remain out of all this. Thank you. Thank you so much.
Thank you so much, Marathe sir. As usual, it was relevant to us as an ophthalmologist. Now with us is Dr. Parikshit Gokte sir. He has some other commitment in the other hall, so he has requested us to take his talk.
To Dr. Viral sir for including me. This is not my core competence. I mean, we have here Deshpande sir, who's an ophthalmologist and a lawyer, and Dr. Marathe, who's worked a lot with the field of law, and you and Dr. Rajesh Joshi, who also have done a lot of work in this. I will be just speaking on professional indemnity insurance myths and facts. So, well, what does indemnity insurance give us, and why do we have to buy indemnity? Nowadays, if you go in any metro, if you want to take a job in a corporate hospital, along with your degree certificate, along with your nationality and your identity proofs and your PAN card, they will ask for indemnity insurance, because indemnity insurance has become mandatory as far as metropolitan or corporate practice is concerned. So it is protection from the risk of paying the liable amount after having been found guilty or negligent. It's a bit like having a third-party vehicle insurance. You are driving and God forbid something goes wrong and somebody sues you, then there is an insurance company which will look into that. So what does the indemnity insurance gives us? The term indemnity refers to an insurance policy that compensates an insured party for certain unexpected damages or losses, usually up to a certain amount. The insurance companies can have a pointer. They provide coverage in exchange for premiums that are paid by the insured parties. And the indemnity insurance is designed to protect professionals and business owners when they are found to be at fault for a specific event, such as a misjudgment. This misjudgment part is very, very important. Certain professionals must carry indemnity insurance, including those involved in financial and legal services. So in the medical practice, indemnity has become much more common in the last 2 decades. But in many financial services, accountancy, they are a norm for many decades. And medical malpractice, errors and omissions are their examples of indemnity insurance. So it is a comprehensive form of insurance. It refers to an exemption from liability for damages. The insurer promises to make the insured party whole again because they will cover all the loss in exchange for premium that the policyholder pays. So these liabilities are settled over time through transfer of economic benefits. I'll not get into the types of it. In the widest sense, it means protection against or compensation for a loss or a liability. So who all needs indemnity insurance? All these years, even accountants, construction engineers, architects, interior designers, marketing and media professionals, travel agents, financial advisors, insurance agents, attorneys, all of these have been buying indemnity insurance. For us doctors, it is something that is relatively recent. It's been there for the last 20, 25 years. But indemnity insurances have always been there because in professions, something can go wrong. An error of judgment can happen and then a person can be sued for it because they have not given the service that was expected from them. So what are the risks that are covered? So things like a breach of confidentiality. So in case some of our case papers have gone out or something like that has happened, if there is an infringement of intellectual properties, there is impaired or unauthorized access, civil fines and penalties, libel, slander, defamation. We have done something which the patient feels is not good for his reputation. But most importantly, what is important for us is breach or delay in duty. So we have given a treatment which the patients think is not to the standard that was expected, or the treatment has been given that has been delayed and the patient feels that, or the patient's relative or the family members feels that because of this some harm has come to the patient. And of course disputed fees, because there can always be a disagreement. But when we look at it, we have to understand what is not covered by indemnity. So there is willful negligence or misconduct. If there is a patient in the ICU who has died and the doctor has not seen him for a day, well, then that may not perhaps be covered by indemnity. We have not done a proper follow-up. It may not be covered by indemnity. Liability arising from illegal violations, like in this country, we can do legal abortion till the 20 weeks. Now it is being changed perhaps to 24, but if something beyond that is done and something has gone wrong and the patient sues, then well, the indemnity insurance will not protect us. So even we have to look at claims before buying the policy. So if you have bought a policy, say today on the 12th of May 2023, and some event that has happened in March 2023, we are perhaps sued for that in September 2023. Since that event had happened before we bought the policy, it is not covered under that policy. Even under alcohol or drug influence, so if the insurance company can prove that the doctor perhaps was under the influence of alcohol or was under the influence of drugs or was perhaps not properly trained, an ophthalmologist has done a surgery, a retinal surgery, something has gone wrong, and the insurance company can say he's not done a long-term retina fellowship, and therefore if something has gone wrong, he's not trained for it and he's still done it, and there is a problem. So then here also they can cite this cause. And of course, in any other major event, the insurance company can always put its hands up. So when we are choosing an indemnity insurance, we have to think of a few things. One is decide the right sum to be insured. So as Dr. Marathe said, that now it can go into crores. So if there is a policy, well, at least a policy of 1 crore or a few crores is something that we'll have to purchase. A policy of 5 or 10 lakhs cover perhaps is not good enough for us. There has to be a full disclosure of information. So whatever we have been trained, all that we do, all the hospitals that we visit, what are the facilities that are available in that hospital, what is the backup there, all of that has to be disclosed initially. If it is not, the insurance company can hold that against us. We have to note the deductibles and sublimits, because many people try to get the premium down. Like this is what we had done with the Maharashtra Ophthalmology Society. So when I was the president, we had a group insurance of nearly about 700 ophthalmologists. But many a times when these policies are sold and they are sold with a lesser premium, perhaps then they may cover only one event in a year, not more. Perhaps they may cover only 50% of what is the cap and not more. And the 50% the ophthalmologist would still have to bear. So whenever we are looking at it, we have to read the fine print, because the nature of risk differs with every business, and so does the premium. Some of the popular ways of bringing down a premium are opting for plans that have deductibles or sublimits. And also look for policy features with your business needs. So if you serve overseas clients, if NRIs come to you, people who are settled abroad, they come to you. Or if non-Indian citizens come to you for treatment and they go to their country, and if God forbid something goes wrong and some of them make a claim against you, then that can be a problem. And finally, just give me a minute, sir. We have to understand that medicine is art, science, and commerce. So each of them is equally important. We were taught only the science part of it, but the commercial aspect is important nowadays. Even in NGO setup or charity hospitals, it's still important. And here we have this great concept of Lakshman Rekha in Ramayana. So when Lakshmana said that he wanted to go out to help Ram, he drew that Lakshman Rekha around Sita. So as long as she stayed inside the Lakshman Rekha, she would be protected from any harm or would be protected from the demons. But minute she stepped out of that Lakshman Rekha, well, then she was just another woman for taking in a forest. So many a times, medicine privileges us. It gives us respect. We get honored for that. It gives us protection. Satisfied patients are our best protection, and it gives us a lot of privilege and access. But if we cross this Lakshman Rekha, and there is nowadays a lot of advertising that is done, surrogate marketing, social media campaigns, all of that, if this Lakshman Rekha is crossed, if we have done something which we were not supposed to do, then all the other protections that are normally there with us because till about 10 or 15 years ago, Indian doctors would never even dream of buying indemnity, because doctors were considered, if not gods, at least godlike. And a patient would think twice, thrice, 4 times before even complaining against a doctor, let alone going to a court of law. That is not the case again. As I always say, Sita had crossed the Lakshman Rekha because she had wanted to feed a poor and a hungry man, which is why she had done that. But many a times, a lot of us cross this Lakshman Rekha, we do it for our own self-gain. And in ophthalmology, 2 or 3 subspecialties which are very demanding for the patients, like LASIK or retina surgeries, and where the outcome is not as predictable as in cataract surgeries, or they are the ones where there has been a maximum litigation. Or in terms of ROP, because the parents, many a times, it's a very precious child. It's an IVF child, and it's a child that has been born, has been in an NICU for 4 weeks, 6 weeks, 8 weeks. And when the parents, to their horror, find that their precious, beautiful baby is perhaps blind, they are extremely angry. And of course, they look at the doctor who is supposed to have treated that baby. So we must buy indemnity insurance. We must read the small print and buy it. But at the same point of time, we must also look at the Lakshman Rekha and not cross it, because in many ways, our ethical conduct and our satisfied patients are still our best protection, and not the insurance companies. So thank you. Thank you once more, Viral sir.
Thank you, Dr. Parikshit, for wonderfully covering proposition is by our chief instructor, Dr. Viral Shah. Dr. Viral Shah has taken tremendous efforts in designing this particular IC.
Sir. So my talk will be basically on the myths and facts regarding the process of obtaining consent. Consent forms are nowadays available online with all the societies, AIOS, DOS, MOS, even in Hindi, Marathi, English, everything. You can always have it. But that is the process of obtaining consents. I would like to stress how we should go about it. So informed consent, the law as it stands today, essential guidelines, what is the problem, why patient decide to sue or file complaints, relevance of a consent form, conveying caring attitudes with information, process of informed consent, and integrating the process and the form. As a starting point, it is necessary for us ophthalmologists to understand some of the basic legal fundamentals behind the consent law. As we all know, informed consent is defined as a process for getting permission towards medical treatment by a patient, granted in full knowledge of the possible consequences, risk, and benefit. Most Western countries are shifting towards adapting the patient viewpoint as against our reasonable physician viewpoint that we practice in India. So what is this? Patient viewpoint means the type of information should be disclosed to a patient that a reasonable person in patient's position would want to know in similar circumstances. The law clearly states that ophthalmologists have a non-delegible duty. It is a non-delegible duty. You cannot say, okay, my sister will be explaining, my technician will be explaining. You cannot delegate. Ultimately, you have to have 1 word, 2 word, 3 word, or half an hour with the patient before he signs the consent. So it's your non-delegible duty. You cannot say in the court of law कि मैंने तो बात ही नहीं किया था patient से, तो हमारी sister लेती है consent ward में. It cannot be like that. And you have to discuss the diagnosis, the nature and purpose of treatment, risk and benefit of proposed treatment, alternative methods of treatment, and risk and benefit of no treatment. All these possibilities have to be covered in your pre-consent counseling. Almost 95% of our ophthalmic negligence court cases that reach the court are decided in favor of ophthalmologists. Then the question arises why the patient felt so aggrieved that he went to the court when the doctor was right, but the patient felt aggrieved. What was the point? So why were such actions filed and without any sufficient legal grounds? The simple answer is that many patients sue regardless because they are surprised by this clinical outcome and they are angry with the provider or ophthalmologist who they strongly believe to have caused the harm. General assumption that most patients are motivated by greedy or predatory lawyers or relatives are unproved and usually not the fact. All data in literature suggest that patients or their family members who file court cases or claim regarding medical negligence strongly believe ophthalmologists did not warn them about the potential medical problems following the treatment and doctors tried to mislead them. Relevance of consent form in such a scenario when such emotional factors are involved, even the best constructed legal consent forms become virtually powerless to forestall litigation. Yet a consent form coupled with the patient's perception that important clinical information was personally conveyed by a caring physician could help to prevent the many unexpected medical results outcome that occur from reaching the courts. A physician who carelessly acknowledges clinical uncertainty and empathizes with the patient's wish for positive outcome forms a therapeutic alliance or bond which many patients will pursue as a caring and personal attitude. Such interaction prevents informed consent activities from becoming mere episodic events which occur only when someone signs the form. So, signing the consent form is not the only event that is of important. Right from the when the patient first visits your hospital or registration counter, from there itself the process of taking consent begins. That is the first encounter of patient with the operative and post-operative treatment phase, and forms and signatures are merely an end stage culmination of the process and not the focus of it. So we have to integrate the process of obtaining consent and the consent form. Informed consent is still regarded in many ophthalmic practices as a discrete legal event rather than interactive process. It is important to change this mindset. Hospital support staff such as nurses, paramedical personnel and administrative assistants must be first encouraged to shift their focus from paperwork of consent to the ongoing process that is happening. Documentation is important but should not be the sole objective during this phase of the process. When possible, start the consent process early, sharing the pertinent information. This doesn't mean an immediate recitation of risk, benefit and alternatives to the patient, but rather an interactive exchange of relevant information designed to understand the pertinent clinical issues and mutually explore clinical expectations. A large number of patients and their families perceived that the doctors would not talk to them or answer their questions. Many believed that no one in the hospital was listening to them. Try to make arrangements to have family members present and included when discussing the patient disease and the planned medical treatment or surgery. During initial or subsequent visit, introduce the consent form and explain its procedure. Clarify for the patient that the form is intended to help both the patient as well as ophthalmologist. Important facts which matter to the patient have been discussed and are understood. Be frank and honest about clinical uncertainties, but don't overcompensate by avoiding potential benefits or treatment either. Give the patient a copy of the form or documentation, either before or after it is signed. Contrary to our belief of many doctors, adversarial note is intoned not when the form is being signed, but when a copy is not made available or graciously offered to the patient. So patient or relatives ask us a copy of that consent form and we say no, it is our hospital record, we won't be giving, we won't share. That itself creates doubts in their mind. You can always give it a copy. There are many studies in US also, UK also, where it has been conclusively proved that there is no adverse outcome if you give to the patient the form. I will just wind up. If patient appears troubled over the risk and uncertainties of treatment, empathize with him, accept their ultimate decision, and if the consent process was properly handled as described, there should be no animosity. When possible, make contemporaneous note in the patient's record during all phases of consent process, even if a form is used. Always put the counseling was done today at so and so time, and again patient comes back for taking a final appointment. Again you can put in that once more counseling was done. Model consent forms. The best way to document such consent forms are obviously model, and AIOS and MOS has done tremendous job in providing us with the consent forms. Each and every procedure you can download it by going on these sites. And if anybody has any questions or need more consent forms, you can always email us or any of the panelists, and we will be happy to provide you. Thank you. Thank you so much for your patience.
Thank you, Dr. Viral, for wonderfully covering the topic. Very important, but from medical point of view, most of the patients and doctors, they are not that careful. I have seen most of the cases are just because the consent was not taken, or if at all taken, was not taken in proper format, and hence the litigations were arised in future. So now the next speaker is Dr. Rajesh Joshi. Dr. Rajesh Joshi will be speaking about medical record keeping. In the past, doctors were just practicing and not giving any paper to the patient or not keeping any record with them.
Thank you, Dr. Viral, for including me in his course. In fact, he is doing it since last 1 or 2 years, and it has been a very successful course. Dr. Viral elaborated about consent. Then Dr. Marathi elaborated about the Consumer Protection Act, and integrities were covered by Dr. Parikshit. But not to invite the trouble about the legal notice, you must keep your records properly. Now, what is the importance of record keeping in ophthalmology or anywhere? You can evaluate your results in long term. Data is available for scientific paper presentation and conferences. Analyze the data for paper publishing in peer-reviewed journal, and helpful in medical litigation. But the most important point here is helpful. It helps in medical litigation because if something goes wrong, you have your record. You never know when you will get the notice. Because the legal system relies mainly on the documentary evidence in the situation of alleged medical negligence. Poor records means poor defense, but no records means no defense. This is the old method of keeping records. You can see a lot of shells which are filled up with records, and you may not find the relevant record you want. So the most relevant system nowadays is the computer-based integration of the records into the software, which is neat and tidy, which is easily stored, and you can retrieve it whenever you need. Data can be easily retrieved. It can be fully typed. These are the various types of medical record systems which are available, and I will be dealing with each and everything, how important they are. Now, how the history records or keeping a proper history is very important. Cataract surgery which went uneventful, but no improvement of vision, patient approached consumer forum. Now the operating surgeon is questioned about the results, but the result was in favor of doctor. Because in history notes, it was clearly mentioned that decreased vision in that eye since childhood, patient had amblyopia and patient developed cataract later on. So this was mentioned clearly in the history. The documentation of clinical findings, how they are important. Now this patient underwent cataract surgery which was uneventful. Patient had recurrent post-op inflammation and iritis with all possible treatment. Eye ultimately went into phthisis. Patient approached consumer forum, but result was in favor of surgeon because preoperative documents clearly mentioned that complicated cataract with all signs of healed uveitis, and cataract was operated under steroid cover, under guarded prognosis. So it is very important to write down whatever you have told patient. Now investigations and documents, how they are important. The patient was diabetic and underwent cataract surgery. Patient did not improve. Patient approached consumer forum, but the result was in favor of surgeon because pre-op OCT findings came in his rescue showing that significant pre-op macular edema which was treated with anti-VEGF, and later on the cataract surgery was done. This is the classical case of documenting evidence in the form of investigation. If the patient has diabetic and cataract, and if you can visualize the fundus and can do OCT, it is always good. Now preoperative care and documentation. Cataract surgery, patient went into endophthalmitis in early post-op period. Case filed in consumer forum for compensation for non-improvement and vision and mental and physical trauma. However, the intravitreal injections were given. Patient was referred to vitreoretinal surgeon. Vitrectomy was done. So everything which was required in a case of occurrence of endophthalmitic event in an initial days were done by the surgeon. So the patient, surgeon rescued. Pre-op case documentation, fumigation and autoclaving of instrument properly done. betadine eye drops were instilled. So these are the preoperative things which were done in that case. So operative note documentation is very important. Cataract surgery was done. Patient had a compromised vision, but still the result was in favor of surgeon. The case paper mentioned that the patient had posterior polar cataract, and doctor explained that this is a problem which can occur with anyone. Patient had vitrectomy on the table, and so the notes were mentioned that patient had posterior polar cataract and the vitrectomy was done properly. OPD prescription is very important documentation. It is important to mention about the name of the patient legibly, date with which he contacted, treatment preferably in capital letters, duration of the eye drops should be mentioned, then signature of the doctor is must. Sometimes we give the prescription but don't sign. So that should not be done. And the review date should be given that you have to come down on this date. An updated prescription can lead to doctor in trouble if patient misuses it. OPD prescription is an important thing. Let us see this case. Patient has giant papillary conjunctivitis. Steroid drops were prescribed for limited period. Patient used these drops for long term and patient developed steroid-induced cataract. Patient sues doc because patient used these drops which was prescribed, but doctor has clearly written that you have to use these drops for such and such period. You cannot use this for long period. So that's why doctor go clean away. Discharge summary is another important documentation. You should mention about the date of the admission, date of the discharge, surgery, surgical procedure which was done, treatment which was advised, and precautions to be taken post-operatively, and the date of next admission. It should be signed by consultant. Copy should be kept with surgeon. Discrepancies in discharge summary and hospital records can raise suspicion about tampering of medical records, and that should be avoided. Referral letter is another document which is very important. It should include date, time of the issue, patient's condition, cause for referral, and duplicate copy should be kept with the doctor. Medical certificate normally we give to those which are required. So maintain the register of this also. So it should include the identification mark and the patient signature apart from the date, name, and everything which you have to write down. Lot of cases of patients misusing medical certificates has been seen. So you give the medical certificate today and patient uses it after 15 days, 1 month or so. So you have to write down the date properly. MCI guidelines, they are not clear about these things for consumer about keeping these records. But can I take 1 minute just? For consumer forum, patient can approach as outdoor case within 2 years and indoor case within 3 years and maintain this record for 2 years. Maintain indoor records for 3 years. If patient demands his case papers, should be given within 72 hours. In pediatric cases, a medical negligence case can be filed by child after acquiring the age of majority. So in medico-legal cases, doctor should preserve until the case is solved. So this is about the summary, and you must keep the record as far as possible. Thank you.
It's about the correct way of tackling a legal notice received from a patient. Sir.
Welcome to all. A notice is issued on the CPA case is lodged. If it is lodged because of either the clinical results, previously it was like that. Behavior of the doctor, behavior of the staff, ambience, instigation, and frivolous complaints to earn money. Now this last portion has increased a lot because of the change in the Consumer Protection Act 19, because the limits which were 20 lakhs to the district forum, that had gone to the more than crores. And so the frivolous cases are plenty where the patients are earning and advocates may also earning. So one can avoid the notice and CPA case by taking all these situations. So remaining things are your hand, but last thing is not in your hand. The patient can send a legal notice as a patient himself or through an advocate or a civil court, consumer court, MCI or state medical council, police station, criminal court. Police station notice is called as a FIR. Criminal court alleged as warrant. Whenever criminal court sends a notice, it is called as a warrant. Doesn't make a difference. Warrant is there, so the normal meaning of the warrant is not there. Or other agencies as health services, corporations, etc. Ophthalmologists should take the steps. In this case, the patient's notice and advocate notice may not be replied. If you are going to reply that, see that whatever you are giving in your reply should not be able to, the patient should not be able to put the same against you. So whatever you are writing should not go against you. He will not refuse the notice, as even if you refuse, it will be taken granted that you were informed. The importance of the notice given is to be informed. You should be informed that something has gone wrong and there is something is litigation from my side. And so even if you refuse it, there is a remark that the patient doctor has refused the notice. So it means he has received the notice. Whether he has to take or not to, that is his difference. But legally, it doesn't matter much. It is not mandatory to answer the notice of the patient and the advocate. Other notices answer with the help of an advocate and or a medico-legal consultant, because the doctor doesn't know the law. And so many times how to represent a notice, how to answer the notice is not known to the doctor, and legal terminologies are not known to the doctors. So he makes many mistakes. He is perfect in his science, his medical things, but he cannot convert it to in the law. Have a indemnity insurance with good, and so that is already told by the Dr. Parikshit. Coverage limit and a medico-legal consultant to as advisor to keep yourself cool. Then don't become panic even if you receive notice. So if you receive the notice, it doesn't mean that you should become panic and you should leave your patients and get disturbed and make the problem. Many times, under the Consumer Protection Act, civil liability of negligence is a solo practice. It is the different thing, and in corporate practice, it is totally different thing. Because of the Supreme Court decision, which has given by them then, whenever a patient lands himself in a hospital, private or government. So government hospitals are also included in that, because government hospitals are charging something according to their income. Many places, and such then they become the consumers. This direct contact is with the hospital and not with the attending doctors or self-individual. Moreover, the patient does not know which of the doctors or the staff will attend him. Therefore, the direct relationship is not between the patient and the hospital. So the patient comes on the name of the hospital and not on the name of the doctor. Many times, though he has come on the name of the doctor, he comes in the hospital and hospital receives the fees, and that fees is taken by the hospital. So the patient is a consumer of that hospital and not of that doctor. So the direct responsibility of the Consumer Protection Act goes to the hospital. So the Supreme Court says the patient, once they are admitted to the such hospital, it is the responsibility to satisfy that all possible care was taken and no negligence was involved in attending the patient. In fact, it is the hospital who engages the treating doctor. Therefore, it is their responsibility. So doctor is giving their services to the hospital and hospital is giving services to the patient. So this is a triangle. So directly in such hospitals, the patient cannot sue to the doctor. Even though they sue, they are called by, given the notices through the court, but easily with this Supreme Court decision, they can be taken out from the suit. Therefore, no individual doctor is liable and can be held jointly or severely liable. Even visiting doctors or consulting doctors in private hospital cannot be held liable. This is a very important thing. My hospital is there and somebody is coming here and doing the surgery and going. So I am liable for his surgeries or Consumer Protection Act. He is not, because the patient has come to my hospital, though he has paid to him, but through me. The consumer patient does not avail the services of such doctors individually by paying fees or consideration to those doctors directly. So he doesn't become the consumer. He can go in civil court, that is different thing. He can go in criminal court, but not in consumer court. When you are receiving a notice from a consumer court, you have to give written statement in the consumer court. Consumer courts, the doctor, neither the patient required to be present personally. There is no questioning directly to the patient or the doctor directly. Only advocate speaks, and whatever is to be done is only in the written forms only. That. So it is given with the help of the medico-legal consultant. It becomes more effective because he has knowledge of the law and medicine. So that is required. He can represent a doctor better way than a normal advocate, and so can win the case. Normal advocate doesn't know our medical terminologies even. Medical things they don't know. So how they will bring what has happened, how the doctor should be brought from that case out. Because he doesn't know the terminology, he doesn't know the complications, he doesn't know what steps to be taken, what not to be. His knowledge is only to the law. But a medico-legal consultant has both the knowledges, and he can defense nicely to the doctor. He can help them maintaining the medico-legal records with the help of the court to win the case. For that, contact medico-legal consultant or a company. Whenever one receives a notice from advocate or a court, consult medico-legal consultant or a medico-legal company and submit written statement with the help of a CPA court. Or in criminal case, give statement to police or present in a criminal court through advocate with consultation with the medico-legal consultant. Whenever criminal case is there is no written statement, nothing is there. So you are called in the criminal court, then you have to present with the advocate there. Remember, complication is not a negligence, as just now Dr. Joshi said. But not knowing the complication happened, not taking the proper steps to rectify the referring or the taking help of the proper specialist, or leaving the patient on unqualified or underqualified substances, if you have not taken the steps, and that should be recorded that the patient is being treated this way after the complication or referred to such, and the signature of the patient on the referral letter should be there. That only takes as evidence in the court. Only saying that and referring is not sufficient. Remember that the treatment as per the standard textbooks and the accepted professional practice, and still patient suffers or injury merely because a complication has happened, doctor is not, because the Supreme Court has said every mishap and death during the medical treatment, the medical man cannot be proceeded against for the punishment. And so medical man is not an insurer, so he should not give the guarantee of the treatment. And in the case of the death, this Supreme Court decision saves him, and so indemnity insurance is important. Thank you very much.
Thank you. Be appointed in spite of, if the lawyer is available, he is not sufficient enough to defend your case. I think the last speaker of the day for this particular session, our friend from Karnataka, Dr. Srinivas Joshi, who will be speaking about landmark judgments. And those are very important judgments in the field of medicine, in the field of ophthalmology. Definitely those will be useful for all of us to study those cases and take proper precautions and how to handle those things.
My elder brother, Dr. Viral Shah, and all the respected faculty here, Dr. Rajesh sir, Dr. Marathe sir, and Dr. Anil sir, for giving me this opportunity. Actually, this was a difficult case for me. To do that, the landmark judgments related to ophthalmology, I think Dr. Viral Dada had given me a real tough job to do that. I would like to acknowledge Dr. Rishikesh and my nephew, Mr. Srinidhi Satyamurthy is now in Mumbai. for this. So, court of record is a perpetual memory and it's a testimony. The judgments, proceedings, and acts of the Supreme Courts are recorded for perpetual memory and testimony. So, I don't know if this has been discussed, but let me little bit rebrush it. Whenever a complaint is received against a doctor or a hospital by the consumer forum or by the criminal court, before issuing the notice to the doctor, the court should first enter the matter to the competent doctor or the committee of doctors. Only after that, the doctor or the committee reports that there is a prima facie evidence of negligence. But the shift has happened recently, not required to have such an expert opinion in civil matters, but still the court can ask for an opinion in Consumer Protection Act case. Now it is totally at the discretion of the court and not a hard and the fast guideline. So section 304A IPC, negligence causing by death any rash or negligent act, it is necessary to prove beyond reasonable doubt the degree of gross negligent act. In fact, section 88 and 92 of IPC are actually favoring, because section 88 act not intended to cause death. So that is done in the good consent, in good faith for the person's benefit. In section 92 IPC, the act done in good faith for a benefit of a person without the consent, especially when it's an emergency case, or if there is nobody along with him and he has met with an accident or any of those cases, then it can be taken without consent. So that is itself approved by the laws. Although it is a cognizable offence which the FIR on table deaths, especially when we are operating on anesthesia, general anesthesia, it might be booked under 304A. Though it's a cognizable offence, but under judgment it is treated as a bailable offence, and doctors should not be arrested under section 304A unless the opinion is taken from an expert doctor or the committee of doctors expert in that above said field. So, for negligence to amount to an offence, the elements of mens rea, means guilty mind, criminal intent, must be shown to exist. Otherwise, simply they cannot arrest a doctor, or they cannot just charge it on the court. And a doctor cannot be treated as a criminal at first instance unless the examination of the facts and the circumstance of negligence in the case prima facie reveals very gross negligence. So I have quoted all the cases also above of the slides for the references. Here came the CPA, that is the Consumer Protection Act, because the Supreme Court of India, the IMA lost the case in the Supreme Court of India, where they thought that the service rendered to a patient by the medical practitioner by the consultation, diagnosis or treatment, both medical and surgical, would fall within the ambit of service. In fact, IMA argued that medical profession is a noblest profession. It is not like banking services, internet services, or any of those kind of services. So it should not be included under the CPA. But IMA lost this case, and the Supreme Court ordered that this has to come under the ambit of Consumer Protection Act. So where the services are totally free to all patients, the government servant who receives service under CGHS scheme or railway is not considered as a consumer. So hence the cases cannot go to CPA. Whereas when the services are paid services to all the patients, then definitely the staff of these hospitals comes under this vicarious liability of CPA. Even the free patients, the charity patients also, if we do, and if they go for a complaint in the court, that also comes under CPA. Why? Because somebody else has paid for that charity. It's not that free it has come. Somebody else has paid the money for that patient. So the money is exchanged. So that also comes under the CPA. So again, which protects the doctor? The nucleus drop occurs if removal is not feasible and it's not possible to determine the exact power of the IOL. If the IOL dislocation takes place, or if the patient does not follow the instructions of the doctor, then definitely these are actually the protecting points, because these are already listed in the textbooks. The criteria for the doctor is no sort of negligence that took place in the OT has to be proved. How much to charge? It is definitely the charge of the medical service. Doctor is not entitled to approach the consumer forum for recovery of professional service. Fees paid for operation also includes under the post-acute. So let's look into a few of these cases. Dr. X versus Dr. Z. It happened in Andhra Pradesh in 2013. The complainant suffered a PCR with a nucleus drop at the time of cataract surgery. There was delay in the second surgery of removing the lens drops and putting a secondary IOL because the patient was having uncontrolled diabetes and also a case of ARMD. The opposite party submitted extract of the textbook, and under the head, the other complication, it is mentioned that posterior capsular rent with vitreous loss is one of the complications of cataract surgery. So is nucleus drop through the rent. So with this, there was no chance for the second doctor, who actually was a complainant, to prove that the first doctor did absolutely wrong and he did not have any evidence for that. So it was not held in the court of law. Now this is another Amulak Ray versus the Dr. X. Again, 17th October, the patient underwent IOL implantation. The post-operative refraction showed plus 17 diopters. Now the most of the investigation relating to the selection of the lens were done by the sophisticated machines. You have to show that. You have to show that the machine was working well, the machine maintenance was doing well, everything was going well. The patient underwent the IOL exchange at another institute, after which he filed a lawsuit. But here, because the machine maintenance and records for everything was shown, the doctor was not proved guilty because it was the error of the machine and not of the doctor. XXS Hospital, Avinash Kumar, 2014. After cataract surgery, dislocation of the same was noted by another specialist who explanted the lens and implanted an SFIOL and also performed ILM peeling in the same sitting. This was not noted by the first operating surgeon due to high grade of cataract and the preoperative and due to postoperative corneal edema, which was managed by the same doctor. But the patient did not follow up because he has to see the post-op fundus, whether there is ERM or whatever, macular pucker or whatever it is there. And the consumer 4 concluded that IOL dislocation was a known complication of the surgery and that the patient was the contributor negligent in not following up properly. Hence, the court did not the further submitted that no expert opinion or document is required at all to prove the negligence in this case. So this another case, the patient had a PSEG attack for which IAC PI was done, following which he developed CRVO and claimed that it's a medical negligence on the doctor because he did the laser and I lost vision. The court held that the doctor was not negligent as he was the best judge who at the spur of the moment tried to carry out the laser treatment instead of giving anti-glaucoma medication in order to ensure that there is no further damage to the retina. And the patient was explained regarding the IAC PI. Patient was deteriorated because of CRVO. The cause may be hypertension, but the patient did not take any treatment at that time. So the doctor was not punished. Now coming to last 1 minute about the ophthalmic camps. We talked so much about this ophthalmic camps, right? So it should not be an unsupervised training ground for the postgraduate. There should be a proper pathologist, physician and all medicine. Now look at this. Original jurisdiction, written petition, Supreme Court. Lions Club, Pottery Town, Khurja arranged an opened eye camp at Khurja after obtaining necessary permission from the Chief Medical Officer of Buland Sahar. In this connection, the club invited Dr. X and team of doctors to do the surgical job. The problem here was the club propagated with the literature that get operated, go home. No restriction on food, no bed rest, no stitches, no that, no this. So 108 patients were operated, 84 patients developed endophthalmitis. The Supreme Court, after this, led the guidelines for how to operate in the camp surgeries. The fault was actually in the saline bottle procured by the government authorities, and the government was actually asked to compensate for each person. So this was again, it happened at a popular hospital in South India. The cataract surgery was performed to 66 patients. On that night, most of the patients started complaining all the signs of the endophthalmitis. 61 of them lost their vision and 5 partially lost in their operated eye. The Chief Judicial Magistrate, which heard the case, convicted Dr. X, that is Director of XXX Eye Hospital, Chief Medical Officer and Chief Administrative Officer under Section 338 for culpable negligence and endangering the personal liberty of the patients and voluntarily hurting them. The court also ordered the payment to all the victims from 2.2 to 5 up to 5.17 lakhs. So this is what happens when it's not in your hands, it's in the chain. So we have to prove that the vendor who gave us all these things and which happened through that, the faulty process, they have to be blamed. So the proper systems have to be in place for us to be secure. So doctor is not negligent if the reaction is not identified and managed in any time acute. So I think the lot of things are there. But lastly, I would like to say discharge cards is very, very important. Poor records, definitely a recipe for disaster. The state commission held that there was negligence as per the case sheet did not contain a proper history with proper treatment investigation, and hence that doctor was sued in the court. And also instances are there that they gave a discharge summary, they unfortunately wrote the wrong date of the surgery. Everything goes fine if all goes well, but in case the patient develops a complication, the lawyers will pick up this point that it has been mentioned as a wrong date, and definitely the court will say that there is no proper documentation of records. So negligence of the doctor is defined as breach of responsibility or the duty, and just the treatment is as per the standard textbook accepted by professional practice, and still the patient suffers loss or injury, then the doctor will not be held responsible for this. Merely because a complication has occurred, that doesn't mean that the doctor is negligent. So as sir just now said, the medical man is not an insurer. He does not warrant successfulness of the treatment or cure of the patient, which is said by the judgment itself. So I think last I would like to say the government of Maharashtra has passed an ordinance where any act of violence against a Medicare service person or damage is punished with the imprisonment up to 3 years and fine up to 50,000. The offence shall be cognizable and non-bailable. In addition to the punishment, the offender shall be liable to the compensation to the pay. So I think this was done in act passed in 2010. I hope all the other states also do such a proper thing. So thank you very much for the patient listening. Thank you, Viral Dada, for this opportunity.
Thank you so much, Dr. Srinivas. That was an excellent presentation. And now Dr. Srinivas Joshi, Marathe sir, Deshpande sir, myself. Any questions from the house for panel discussion?
Important question from... Okay.
You can take the mic.
Sir, I wanted to know one thing. Like if we operate a patient, and even before operating the patient, we get an idea that how patient is going to behave with us after the operation. And during surgery, there is one complication. If we refund all the money deposited by that patient to the hospital, OPD fees and surgical fees, even then can we come under consumer court or not?
You have taken the money before the procedure, so you come under the...
So if we have refunded,
You cannot refund it.
Still you are under the...
He is having the right under 3 section where he can go in the consumer court.
I think your CGHS patient or the government sponsored scheme, they don't come under the Consumer Protection Act. But rest all the fee paid, because somebody else is fee paid for that patient.
Or your question may be little different. Probably you wanted...
CGS patient come under CPA Act. CGS patient also come under CPA Act. Patient can directly sue.
Then I don't think it comes.
No, government hospital, doctor has some different laws. Dr. Rajesh Joshi knows.
No, the thing is that, as I mentioned, in government hospital, trust hospitals, corporate hospital, the liability goes to the hospital, not to the doctor.
Vicarious
Because
liability.
that is because of the Supreme Court decision and National Forum decision. Because the patient is paying the fees to the hospital and not directly to the patient, doctor. So he is not the consumer of the doctor.
And in fact, refunding him on the same day, it only
I think
make him more कि कुछ ना कुछ गलत हो गया, गड़बड़ है, मेरा तो गड़बड़ हो गया.
your question may be from different angle. Returning the same amount what patient has paid because you thought some complication was there and patient was asking for refund.
Yeah.
Another thing is because there was some complication, you have paid the amount which is not related to the what patient has paid you, maybe little more, just to settle the case. So that is again the refund scenario.
like sometimes one doctor is referring the patient to VR surgery, and they say that there will be charge of around 50,000 for this retinal surgery, and I am paying for you. Even then, he can file a case.
Yes.
Even if you settle the case outside the court without the permission of the court, still the patient has the right to go in the consumer court and put a case.
Okay.
The compensation, that is mediation cell, is there.
What is trying to trying is, as there is some complication, he has referred to his retina colleague, and he has retina colleague not to charge anything. He will settle the bill, and if even after that retina surgery there are complications, yourself and retina surgeon both will be in the purview of CPA.
Okay.
I think sir wants to ask something, or can add to this as a retina surgeon.
It's a very important session. Very important. I think this should be in a bigger hall and more people should attend. I just want one comment to make that from our mindsets, we should actually remove the word free. In economic sense, there is nothing falling from heaven or sky. When the consumer is not paying from out of pocket at that point of time, we are generally calling it free, but nothing is free. As has been told, someone is paying for it, either a third party insurance. When we say, someone else is paying, even if it is CGHS, or it is the taxpayer is funding it. It's not as if it is coming from somewhere else and it's, you are printing money for that. No, someone has to subsidize whatever treatment is happening. So from that perspective, I think if you look at the law, if we have to be fair to everyone, anybody who is coming for a service, whether party Y is paying, party X is paying, or I am paying partly, whatever it is, there is an expectation of a minimum standard, and that is what is being judged in these acts and overall care. So from that point of view, I think all of them we should be taking care of. Whether you refund it or you don't refund it, you are still liable to that standard which the court or the country has made for it. So that's the point I want.
He can go to the court of the law, but he cannot prove negligence. He felt aggrieved. आपने पैसे दे दिया लेकिन उसको लगा जो काम करने आया था वो तो हुआ नहीं, ऊपर से मेरे को दर्द चालू हो गया, ये चालू हो गया. He is aggrieved. Whether you are negligent or not, that will be proved in the court. But he has a right to go to the court.
My next question is okay.
Yeah.
In case of that, don't refer that. If you refer that, then the patient will definitely have a doubt that.
But the patient may or may not be able to do that because what doctor has used, he doesn't know.
And other things like there were some cases like that polluted water was used while cleaning the instruments or washing the hands, something of that sort. And because of that water tank problem, the water was polluted. And such case, there are endophthalmitis. Then
The responsibility is with the management of the hospital. So, if the corporate trust or any other hospital is, their responsibility is there. Doctor, that is not the responsibility of the surgeon.
If it is a solo practitioner, doctor is
Then
responsible.
solo practitioner, he is own whether from this pocket or that pocket, it goes one and the same.
Yes, please.
This is the second question, sir. Sir, I am also VR surgeon. I have done a long-term fellowship. But nowadays in my city and in nearby areas, normal MS, they are also giving intravitreal injections and they are doing ROB screening also. So, and they are doing ROB screening and they are giving intravitreal injection also. So legally, how they are doing correct or they are wrong? Because once when I was having conversation with them, they told that only MS degree is recognized by MCI and not any other fellowships. So what is the legally?
Legally, they can give injections. MS, they can give injections, but if it goes in the court of law, if the patient feels aggrieved, then court will definitely ask them whether they have been a full trained, they have received any training in this retina specialty or not. Court is now aware of this various specialties there. So in court of law, he will be on a loose footing, that doctor.
Otherwise, they are
allowed.
They are
allowed.
And about your personal comment, suppose he is your rivalry or your competitor. From that angle, one-to-one, you shouldn't complain, number one. If at all you want to complain, then there is a procedure. You'll have to take direct fighting with that doctor. Third thing is, you cannot break the rule on your own, even if that is done wrong. If someone else complains, maybe patient complains against the doctor, then the government authority or medical authority will take the decision about that. Like most of the doctors who are not trained and doing that particular surgery, the other doctor cannot go against him unless it comes to him. The same way, if the competition or jealousy or some rivalry is there, that is a different scenario.